Ladies and gentlemen, good morning. So nice that all of you are joining us in. My name is Leila Latif, calling in from Nairobi, the University of Nairobi this time around, and I am joined with a fantastic panel of tax experts. We have Professor Keith Angels with us, Dr. Martin Hearson, and our very own learned friend, Edwin Balaba, who will be taking us through an understanding of tax treaties. So without much further ado, I'd like to start off by calling upon Professor Keith Angel, who is the CEO of the South African Institute of Taxation, and he will speak to us about the role of double tax treaties and basically their usefulness in promoting free trade. Professor, thank you so much for honoring our invitation. The floor is yours.
Thank you so much. I appreciate this. This was a nice surprise offer. So here we are. Just to say a little bit who I am. You hear a funny accent. I'm originally from the United States. I was born there. I was a tax lawyer there up till about age 38 or so. Then I came over to South Africa. I joined the South African National Treasury. I was in charge of their legislation for quite some time in tax. Did that for a long time, then worked for a firm, and now I'm the head of the South African Institute of Taxation, as you see here, which is a professional body for all tax people. So lawyers, accountants, and so forth. So there are tax institutes you'll see, like in the UK, you'll see this in Nigeria, Ghana, and others. I know they were thinking of forming one in Kenya, so that might be a little more closer to you. And I know there's some group that's in Uganda. Anyway, just to give you a little bit of background. Now, one of the things that we talk about the East is about unity. You'll see a lot about the trade, EAC, which is basically about trade. Tax treaties are more about investment. And so there is some discussion about an EAC agreement where they'll have a multilateral agreement in order to promote the free flow of investment, which often attends trade. So think investment here, not like trading of goods necessarily, but there will be activities and cross-border activities. So when you're looking at this, as we begin, I will start, is the international tax treaties. International tax treaties sit on top of domestic law. So they mainly sit on top of your domestic income tax act. And all of you have income tax acts. And the question is, how do those income tax acts work together? Because if you're going cross-border, and let's say you start in Kenya and you move to Uganda, or you have a business in Tanzania and you want to extend it to Kenya, well, how those extensions go, once you're in two countries, you have two countries' tax system to deal with. Once you have two countries' tax system to deal with, life becomes more complicated. And the purpose of the tax treaties is to simplify that. And it's generally designed to assist business as a general matter, and give you just a context there. So when we look, the main issue here, you'll see cross-border double tax and tax treaties. And what this is about is that you've got two tax systems. So in a typical scenario, you've got the head office in Kenya. Say the head office in Kenya's got operations there, and they want to put another business somewhere in Tanzania on the port. And now you've got two locations. Who taxes you? And do you get taxed twice? And the big issue is in international trade, not trade, international investment, is you don't want to be taxed twice. So thinking about it very simply, I think the average rate of a corporation on your side of the world is 30%. Well, if you've got one putting 35% and another 30%, you're talking about more than half your income going to taxation. That's a lot. And that's enough to dissuade cross-border activity. So what you're trying to promote is promoting cross-border investment so that when you go to the second country, that you don't have double tax on the same amount. That's what we're talking about, not being double taxed on the same amount. And typically what you're talking about is the flow of capital and then goods and services, but differently. So when you talk about customs, you're talking about importing goods. Customs just deals with goods. You're importing goods. And that only deals at an import level. But the issue is income. When you look at income, you can earn income on goods or services or capital. And the question is, where does that income arise? And do both countries claim they have a right to that income? when both countries claim they have the right to that income, and you look at domestic law in Tanzania and Kenya, and you say, oh, Tanzania says it's theirs and Kenya says it's theirs, who is it? And so that's what we're trying to limit with these treaties. And that those treaties can be with any country that you want. So that's what they are. There's also a growing push to use treaties to stop avoidance and evasion. So we'll get back to it later toward the end, but the tax treaty should not be used so that you move things to a zero tax position. It's not to get to a zero tax, it's to make sure that if there's 30 and 30, it stays at 30. And that's the main element. I think it's sort of gotten lost over time, that main element, when you're looking at it. Just for you lawyers out there, please note that tax treaties are governed in a sense by their own separate laws. So that when you're looking at a tax treaty, you've got to take into account how other countries treat the same wording. So there are different books on that, and it's a different area of specialty. Don't just look to your domestic case law. Just since you're all lawyers there, I thought I would add that in. Okay, double tax treaty models. I don't want to take too long here because we do got to move things along. Bottom line is this has been dating back for a long time. There are two models. One is the OECD, i.e. the European model, and the other is the UN model, which is for the developing world. They all date back. The OECD model originally came out of the 1923 UN League of Nations. Back then, that was the OECD. Everybody else were colonies, if you remember. So that's the UN League of Nations. When later it became the OECD. So you see they date back, and there's been many versions. So the one version is more of an OECD version. The UN model is more of the other version of the developing countries, which came out of the 43 Mexican model. And you'll see that's also there, but it tends to lag. But essentially what the issue is between the two models is one country tends to be an exporter of services and investment, and the other one tends to be an importer. So the typical way to see that is you're a European, well, I guess let's say it's an English parent company in the United Kingdom. The United Kingdom invests in Kenya or Uganda or in Tanzania. Now, again, at that time, you had the Germans a little bit in there in Tanzania, but the British took over. But the bottom line is when they were investing, what they didn't want was if you had a UK tax, you didn't want a second tax popping up on the same income from Kenya or Tanzania and whatever. Remember, they were the colonies at the time. So the world was that when you invested abroad, UK got the first right of claim to tax, the local colonies got the second right. So the OECD is built on that model that the exporter country, the United States, whoever is the investor country, gets sort of a higher claim, and it tries to limit that claim. And when you're looking at the UN model, they're pushing much more to say, we don't want to forego our rights to taxation in favor of the investor country. And so that's what the battle is about, which country gets priority. But the bottom line is in a double tax treaty, you limit it to one. And right now, sometimes where agreement can't be made, then you will see double tax where it cannot be resolved by treaty. So just a focus there. 1.2 that's the exporting countries know what they want to do. The importing countries tend to be confused. And part of the one hand is if you're a British company and invest in Kenya, the Kenyans want to preserve their right to tax. But on the other hand, they don't want to cause an extra tax on the UK investor. So they are there for the UK investor decides not to come. So the tricky part for an investee country is how they balance that, because if they go too far and they want too much, then the other guys don't come. And then that's the problem. So you're balancing your right to taxation as a local country versus the desire for investment. And that's where a lot of the confusion comes, because leadership often doesn't know what's what. And one day they're looking for investment, the other day they're looking for tax protection. And they don't see how the two are tied, and so you'll see policies confused and not necessarily balanced properly. Then we just go to coverage. let's just say that it's always, there's got to be an overlap. So there's got to be a UK company doing operations in Kenya or a Tanzanian company operating in Uganda. There's got to be that overlap. That's the trigger for it. If there's no overlap, there's no treaty, don't worry about it. Main thing is income. We're talking about the income tax and the capital gains tax. Those are the main ones. Things like Social Security, not such a big deal. Gift and estate tax, a few countries have that, but I wouldn't worry about that. It's really an income tax thing as a general matter. Yes, there'll be some funny taxes, but just don't worry about it. That's not really critical. So just leave it at that. Okay, the binding nature of treaties. Now, one thing that is very unique about treaties is they're binding. So the domestic law can change, but the treaties will still override domestic law. So foreign investors look at treaties as another layer of protection. And one of the things that's in the background when you think about treaties is when foreigners invest locally, they're very afraid of discrimination. And the reason why they're afraid of discrimination is foreigners don't vote locally. So if I'm a British UK resident and I'm visiting here in the East, well, the bottom line is my vote doesn't matter. And so how do I guard against populist laws that are anti-foreign? And this is a problem across the world. And all countries, no matter what they say, it's always easier to tax the foreign guy because the foreign person doesn't vote. And so you'll often see, even in the United States, a lot of rules for people on the foreign side, can get a little bit hostile. And, you want to have a treaty to protect you against those waves. So that's why they're binding. And typically they're binding somewhere in your law. In the US, it's above domestic law, but it goes in there. There's a way of fitting it in. So the one thing you need to keep in mind, though, is that treaties can be revoked, but it causes a political problem. So you don't really want to revoke. Is it, ministers of finance, revoking a political treaty gets them into trouble with the diplomats. So you generally, once you have a treaty, you don't revoke it. Oftentimes you ask to renegotiate it. Every once in a while, you'll see a revocation. So you will see right now, certain countries are under the suspect list because the treaties haven't been used the way people are comfortable. So for example, Mauritius got in trouble with Senegal and Senegal revoked the treaty. So there are issues of revocation, but you generally don't like doing that. So you'll find that the treaties are rarely revoked. They are much more stable than domestic law. And even if they are revoked, they often have a notice period. So like a year, 2 years, or 3 years. So you don't get caught by surprise. An important thing there. Okay. Now, what are you resolving? What kind of thing here? So this is a good grid to keep in mind, because oftentimes people get a little bit confused about these things. And the bottom line is that they're only designed to eliminate certain kinds of double taxation. And that is, when you look at the Income Tax Act, there are two bases of which you can claim the ability to tax in any country. One is by virtue of the people, which is called in personam jurisdiction, or you can claim tax by virtue of the activity, kind of in rem jurisdiction, the thing. So if you are a Uganda resident, Uganda has a right to tax you by virtue of your residency. If you're a Uganda resident and you invest in Tanzania, they still have a right to tax what you're doing in Tanzania by virtue of your residency. If, however, you are in Tanzania and there's a UK resident investing there, there's another power, which is the power to tax by virtue of the activity. So if I'm active in Tanzania, doing things, generating income there, well, then I can claim it as well. So a Uganda person investing in Tanzania will have a claim by virtue of the Uganda government by who he is. But now that he's operating Tanzania, Tanzania will also have a claim by virtue of what they're doing in Tanzania. So that is your classic issue of double taxation. Uganda is claiming tax over the Ugandan for operating in Tanzania. And Tanzania is saying, well, what you're doing in here, we also have a claim. The Tanzanians, though, can only claim the activity because they're not a Tanzanian resident. So they can't go reaching into Uganda for Uganda activities because they don't have that person there. So you take a look, and what we call them is, there are two kinds of things. There is a there's a resident source conflict, which is what I just described. I'm a foreigner and I come into your country and my home country is taxing me by virtue of who I am. Now I'm visiting you and you're also claiming tax by virtue of the source. So that's called a residency source dual claim. And that's what Articles 5 through 21 and 25 typically go after. There is something that's more rare, but it comes up, which is a dual resident. I've spent part of my year, I'm here and you're there. So typically, if I've spent maybe, a good chunk of the year in Uganda and then a chunk of the year in Tanzania, well, Tanzania and Uganda go, you belong to me. Maybe you'll both claim you belong to me. Maybe you're, a citizen and there's certain activities you'll have. So for example, if I generally live in Uganda, but I spend most of the year in Tanzania, because my family's there and my basic ultimate assets remain in Tanzania and Uganda, I'm still a Uganda guy. But I'm visiting for a long time in Tanzania. And for this year, Tanzania says you're a resident as well. So sometimes you're claiming it dual by person. Sometimes you're looking at person and source. So when it's by residence, dual residence, you'll see Article 4. When you see claim by residence versus source, it's the other articles. There is rarely a time where both claim via source. So let's say you've got a UK citizen who lives in the UK, but they invest somewhere in Africa, in East Africa. It will be rare that both Kenya and Tanzania will claim the same source. But it happens on occasion that they say, well, it happened in my country. No, it happened in my country. One area what happens is services. So in services, if I'm in the UK and I do everything in the UK and I do a legal opinion, I do it in the UK and I send the email to Tanzania. But where did I do it? I did it in Tanzania, in the UK. But I'm in Tanzania. I sent the email to Tanzania, and Tanzania says I'm paying out of Tanzanian money. Now, in the old days, it was just UK tax because services are services and you look to where they're rendered. But in many African countries, they say, I also have a claim based on where the money comes from. And so you're looking at the activity versus the payment, which is dual source. And tax treaties do not resolve that issue. And that's because OECD style treaties were the norm up until the last 10 years or so. And now with UN type treaties coming into play, source countries are claiming greater source jurisdiction. So those are typically battles and you have to work them out. And that's an area where I'm sure you'll have to write a lot of legal opinions. There's a lot of issues in that space. So keep that in mind. Again, I've showed you here residency source. Residency is I'm a UK resident. I live in UK, and now I've got some activities in Kenya. Source. So that's the dual, and that's the bulk of what treaties are about. Okay, just to know some early thoughts. The original guys who made the treaties dates back many, many years. So tax treaties actually date back to the late 1800s, but there weren't too many. Back then, one reason there weren't too many is the income tax didn't really exist. So the income tax, the British were the first to enact it in 1799. They dropped it. They brought it back in 1841. US 1865, after Civil War, they dropped it. Europeans sort of had it, but nobody really got going until 1914. But there was a little bit of issues, typically between Britain and its colonies, but there was a couple of European ones. And so they started forming, once income tax became widespread, that was due to World War One. And in World War One, we were taxing income, which we now all live with. And therefore, the need for a treaty grew, and that treaty was done. They began talking about what the model would be, and it was driven by the United States, the British, the French, the Italians, the Germans, and the Dutch. The Germans, of course, had lost World War One, so nobody was listening to them. Dutch was small, so nobody was listening to them. The Italians were also small, nobody listened to them. And so it ended up being a British-American show with the French joining in. And the reason why was Britain and France had lots of colonies. And so this was going to regulate how a lot of the colonies operated. And the US was an emerging superpower who wanted to invest across the world. So they actually were the main drivers of this whole thing when it came to the details. And a guy named Adams. But the main thing what they talked about was, if you are operating, it was from an American perspective, the Americans said, look, if I'm operating in the United States and I'm subject to 30% tax on my corporation, when I go abroad, if I'm going to face another 30% tax, I'm just not going to go abroad. So the point was the location, the foreign investment location, their tax was seen as a barrier to trade, because that second charge would come in and that would kill me. So what the treaties do mostly is limit the local country's right to tax. And they will reduce those taxes. They'll say, okay, the rate's normally, higher, and we're going to lower it lower. And what they generally go after is cross-border flows. So what you'll see it as is, let's say I am a British company and I invest in Kenya. And let's say I set up a Kenyan subsidiary. So UK company sets up a Kenyan subsidiary. Well, the Kenyan subsidiary is a Kenyan company operating in Kenya, and there's no issue. But then when you want to take the money out from Kenya to the UK, that's when the treaty kicks in at that moment. Mostly it's a repatriation charge, so that on repatriation, both are going to claim a tax, and the treaty then says, well, when I'm getting them, here's the UK company investing in Kenya. They've been taxed once in Kenya for their earnings. Now, when they want to pull the money out, there's a second charge on dividends or interest, royalties, whatever. And that second charge is where the battle goes on. Most treaties limit the local country, OECD style treaties. UN treaties try not to do that. They want to limit more the other country indirectly. So that's what all this was about. And if you want, there's some website called Tax Treaties. And if you look it up, it's on the website, pretty easy to find. And they give you the entire history of tax treaties. And you will see every little document in there. So in case you're looking to do a doctorate thesis, that's the source. And again, when you're looking up deep issues, you can find it there. It's quite good. Okay, so let's move it along a little bit. I've just got getting deep in. So I'm going to go quickly here a little bit. When you look at treaties, there is Article 4, and it's about residence. And typically, who claims, typically local countries claim based on different things, but the most important usually is days. So if you spend more than 183 days and you're an individual, more than half the year, you're likely to be taxed locally there. Other things are connections, like where's my family? Where's my home? Where's my car, my license? Where do I vote? So you can also get there. US claims on citizenship, doesn't matter where you are. So the treaty says, look, if we've got a problem where it's dual because of you're sort of going back and forth, you've got activities in both locations, they have a tiebreaker clauses, which then shifted to one or another. So let's say you are in the UK, you live in the UK, your family's in the UK, but this year you spent 300 days in Kenya because it was a big project. Well, Kenya will say, you've been here too long. We're going to tax you as a resident. But the tiebreaker says, where's your permanent home? And the permanent home is in the UK, and therefore you're done. So they look to your permanent home, your closer connections, and they say that's more important than days. Habitual abode. You've got the same house for years, but your vacation home, ignore it. Then sometimes they turn to nationality if they're desperate. And then if they run out of that, they have something called competent authority, which is by mutual agreement. I'll come back to that in a moment. So you will see a number of those things for global mobility, cross-border employees. That's where it usually comes up in your space. People who are visiting to work for a temporary period of time is where the treaties will often help resolve dual claims. Other issues, is companies. So typically there are two places you can claim: your place of incorporation or effective management. And typically what treaties go for and countries go for is effective management, i.e. the board of directors, where they regularly holding meetings. So the South African, you'll see here, because I'm close to South Africa, they have special rules and how they interpret it, and your countries will as well. They might have some notes, they might have some cases, they might follow a practice. In Kenya, they might follow the UK approach, or maybe the Zimbabwe approach. They'll follow different approaches. I mentioned Zimbabwe, but I think Zimbabwe actually looks to Kenya. But there's a connection there. So South Africa's got its own interpretation note. So you'll typically look to effective management over place of incorporation. And that's usually what prevails in a treaty. But if, let's say, both claim effective management, then what do? Well, then, the only thing you can do is resolve it by looking at the case law, and you try to argue, looking at the case law around the world, what it is, typically where the key board members are, where they're operating, all of that is what comes into play. There's a number of books on that as to how you can do that. OECD has some. But if both countries say effective management, let's say you've got 9 members on the board, and you're meeting virtually in one place, physically in another, and people are living in both countries, there might be a dual claim. You then have to go to both countries' tax authorities, called competent authority, and say, guys, you can't tax me twice. Please resolve this in something called a mutual agreement procedure, a MAP. And so what happens is the Kenyan Revenue Authority will meet with the HMRC, and they will say, no, it's me, and they'll work out a deal. But it's very hard to get those. That takes 2 to 3 years. So oftentimes you're stuck with double taxation. But that's what the treaty is supposed to do. So that's one. Let me move on. I don't want to go too far. The other one is the resident source conflict. So when you look at that, as I said, I'm just keeping an eye, there are different things that could happen. Typically, you're talking about different activities. The one that's most common is foreign company sets up a local subsidiary. That is the most common situation you will have. Sometimes the foreign company will operate directly in your country. Generally, they do that because they're not big enough yet. And it usually comes up because you've got a couple of employees running around, and they've got some contacts, say, with Kenya. The UK companies got contacts in Kenya, but they don't really have that much business. So they have employees visiting there for maybe a month. They're doing some things. They've got some connections. And those connections sometimes can create a local taxation. And that it's often by accident that you are deemed to have a local branch effectively, which ultimately deems you for the local guys to tax you. So that's where a lot of little fights come up, accidental permanent establishments, as we call it. So, but the main one is between the foreign and the local. And then what you're looking at is passive versus active. Passive is rents, royalties, dividends, all of that stuff that you're not working day to day. Active is typically sales of manufacturing stock, people providing services like law services. day-to-day professional services, day-to-day business, that's active. And the tax law all around the world looks at passive one way, active another. They're two different worlds. Most of the abuses are the passive, or active disguised as passive. That's the other one. So you get a lot of different issues between the two. But if you look on my picture, foreign company with local subsidiary, local company, the local company's active, if it's a Kenyan company doing Kenyan operations, well, then the Kenyan company is in person jurisdiction, Kenya company. If it's Kenya activities, there's no issue there. It's only when the local company makes a distribution to the UK foreign company back home. And that's where a lot of the treaty provisions kicking in. And then you'll see that on that side. And then when you're operating without a local company, the treaty tries to define clearly what is a branch that's strong enough that the local country can tax. Just tiptoeing in the country is not enough. And so the treaty is designed to say the activities locally have to be substantial. If they're not substantial, the local country forfeits its right of taxation. So minor branches or non-real branches, that's what gets exempted locally. But once it's a serious branch called a permanent establishment, then that activity is fully taxed locally, and that they get the first right of taxation. Now to note, because I've just got to keep an eye on my time, so I'm jumping around a little bit, is that the foreign company, when you see foreign direct activities, they have something called tax credits. So the way the system works is the treaty will eliminate tax completely on the source country if it applies. So if they don't deem it to be local, that's it. On the case of the foreign investor says, fine, you have the first right of taxation, and I will give a tax credit to my company. So in a simple case, let's say, you're a German company. I'm not sure. I'm trying to figure out what the German rates are, but let's say you've got a 35% rate of tax. That was the old US rate, and you invest in Kenya. Well, if you have a 35% rate in the United States and the Kenyan rate is 30%, and the treaty applies and says the Kenyan company is the first right of taxation, what the US does is they say, okay, we're going to apply our 35, but we're going to subtract 30 because Kenya has 30. So Kenya gets its 31st, and if our rate is higher, that extra 5 will tax. Now today, the US rate is 21. So if the Kenyan rate is 30 and the US rate is 21, the US just forfeits. Similarly, UK 19, Kenya 30, UK would forfeit. But they do it by virtue of a tax credit mechanism. That's what they do. And the treaty's got one article on that. So that's where we go. So just to go through passive income, again, as I said, here's the example. Passive income, you got a local company, say a Kenyan company with 30% rate, it wants to distribute a dividend. And again, Tanzania will be the same, so will Uganda, so will Rwanda. I'm not sure who the other one that's in that regime. Is it Malawi? That may be the other EAC company in there. Sudan, I don't think is yet in that space. But the point is, all those countries will have tax on the local company. So a Tanzanian corporation does things in Tanzania. That's it. Maybe they're doing farming, they're doing mining. Boom, they hit it. 30% rate. But when they want to bring it back home, they're going to want a withholding tax. And a lot of the rules, which you will see here, is that the dividends, there are withholding taxes. So we go to dividends. If you bring back dividends, the local rate might be 20 or 30%, but the treaty, let's say it's a Tanzanian charge of 20, they'll reduce it down to 5 or 15 or maybe 10. So the treaty will reduce the Tanzanian local rate or the Kenyan local rate when it comes out. So when you're repatriating, this is when these taxes come up as a practical matter. And this is a big issue for foreign investors because they look, you've taxed me once. I want to bring my money back home. I put my money in there to bring money back home. I didn't put money in there just to sit there forever. I want to bring it back home. And if I'm going to be overtaxed for bringing that money back home, I'm not going there in the first place. So the treaties often limit that charge. And then the UK will then jump in. Different ways. Sometimes the UK may not tax at all under something called the participation exemption. So you'll see in Europe, repatriating money back home comes under the participation exemption and they don't tax it. So they don't want a second charge. And if the local country does that. So the dividends article comes in. Most African treaties limit the dividend rate to 10%. It's a general 10% rule, which follows the UN. There's also something called capital gains. So I've had this company for a long time, and now I want to sell it. Well, when you sell the shares, is it local country or foreign? So if you sell Kenyan shares, well, the way it works is Kenya would say we have a right to tax it, but then the treaty will say, forget it, let the UK keep their money because it's the shares, it's not actual operations. Whereas Tanzania wants a claim on that underlying, and the treaty might override that. And so Tanzania will claim first. So you'll see a lot of fights about moving subsidiaries or selling subsidiaries. Another one is the big issue about base erosion you'll hear about, and that's interest. Corporate local, say a Kenyan company pays, well, here's our favorite, Mauritius. So UK company goes to Mauritius, Mauritius goes to Kenya. And there's a debt, a loan. Kenyan doesn't put shares in there, they put a loan, and they say, we're gonna put all the money in by a loan. So capital goes in and they want to be repaid by a loan. When you get repaid via a loan, there's an interest deduction. That means your local company tax is lower. So let's say you've got a Kenyan company that makes R1 million, but it pays out 800,000 in interest. The R1 million of net income is reduced by the interest payments of 800,000. That reduces their tax to 200. Then the 800 pops up in Mauritius, and then Mauritius can claim taxation, but Mauritius works it out a way they exempt it completely. So what happens is interest payments or deductible payments leaving the country are what is seen as base eroding payments. And there, the local countries fight a lot harder. But again, there might be a second tax. So there's a deduction, there's a second tax, which will come out interest payment. So the interest payment leaving Kenya deductible, then there's a withholding tax on the receipt by Kenya, and then that often gets reduced by treaty. So those are slightly different, but it's the payment, the receipt of the payment that the treaty provides relief for. The interest deductibility is determined by local law. So that's just a feeling of where it's at. And my time is running out a little bit, so I'm giving you those. Royalties, all of those are the same. If you take a look around, I said tax credits. Tax credits are the home country. So the foreign investor, in order to prevent double tax, will give relief. So for example, if American company receives interest, so you got a Kenyan subsidiary, interest is paid to Kenya. Kenya might claim a tax treaty, tax amount. They'll say, look, I'm getting a deduction here. The local Kenyan company is deducting it, but when it goes out and is received by the American company, we want our share of tax. Could be 30% on the withholding. What happens then is the treaty will reduce it to 10. And the US will then have its own tax of 21, but they'll say in tax credits, okay, Kenya took the first 10, we're going to get the next 11. And that's where the home country gives relief. Okay? Just having to move quickly. So another one here, I'm just going to go to is active income. As I said to you, if you operate in the country, you set up an office, or you have a warehouse or local activities, local people moving around, the treaty has a number of provisions: a dividend, capital gain, interest, other income article. So it's typically dividends, interest, royalties, capital gains, and other income. That's usually the passive stuff that we were talking about. And the source country limits its right and reduces its withholding taxes. And then the home country, the exporter, the country where the investment came from says, okay, you reduced your tax by that amount, we'll respect it, and we won't double tax. So we'll reduce our rate by the amount you claimed. Now, those are the articles you said, dividends, interest, royalties, capital gains. There's something called a permanent establishment article, and there's a profits article. And what they're trying to figure out is, do you have enough activities to be taxed locally? If you didn't do much locally, you don't have a permanent establishment, the local country gives it up. That's generally the way it goes. So what you typically have is two things. You've got, I'm trying to just get to it. You typically have something called a permanent establishment. You say, is this activity sufficient? And that's a permanent establishment. And they go, okay, usually it's sales. You see here manufacturing, or it looks like some sort of factory. That's going to be a permanent establishment. But they have exclusions. But they especially include a branch, an office, a factory, a workshop, a mine, oil and gas well, all of that. So if you just own a mine directly, not through a subsidiary, or you've got a factory, local country is going to prevail. And then so if Kenya's taxing at 30, let's say an American company's got a Kenyan factory. They don't own a Kenyan subsidiary. The American company owns the Kenyan factory directly. Kenyan will claim it first on a 30% rate, and the US will say, we're going to apply a tax credit, which means we will tax you anything above 30. But they only have a 21, so they forego it. So those are definitely permanent establishments. But then they have exclusions, and they exclude things like warehouses or typically ancillary activities. You'll see all these minor things that don't contribute to production or sales. And there was a whole battle going on here that all these minor activities, are they substantial or not? So the treaty excludes a lot of them, but now they've revisited and narrowed these exclusions. And that's sort of this big fight that's going on in Europe and the OECD to narrow this so that you can't duck and dodge your way out. Because people were playing games where they were doing real activities, but they were hiding behind legal mechanisms to say they weren't. So that's what that's about. So whether you have it, and whether the other one is whether the income is attributable to. And just to note, I'm just giving you this one, employees and dependent contractors can get you in trouble. Okay. So if I had more time, I would give you that. But what happens there is an employee that's running around doing a lot of activities can be deemed to be a permanent establishment. One, the employee can be taxed directly by what they do, because if they're in the country too long, they can be a resident or their activities can be taxed locally. The second is those employees could be viewed as a permanent establishment, and then the home country is going, then what's going to happen is the EAC will be able to claim it. So if there is guys that are there, too many guys, too much activity, the local country taxes it, and then they can only use those taxes to credit against the foreign. So a lot of issues, and I'm sure you'll bring that up as lawyers.
Thank you,
Last
Professor.
What?
Yeah, I think this has been a really fantastic discussion. I was just wondering whether you're able to now try and wrap up in 2 minutes, if possible, please. Yeah, thank you.
So that's what I figured. So let me just jump to one last thing called treaty shopping. Okay. Treaty shopping is where we play a little game. I don't know, I've got a little misspelling there. But what you've got is, let me move the one that's fairly popular. Treaty shopping is when you put in a false company that's not doing anything in order to lower tax. So the typical example is India. US company invests in an Indian company. And the US has a treaty with India, but they don't like it. It doesn't do enough. So for example, India, if a US company sells an Indian company, the Indians will claim local capital gains tax. And most local companies don't do that. Local countries don't do that. So people hated this capital gains tax that if you sold Indian shares, the Indians would claim it. So what you do is you put in an intermediary company, which at the time was Mauritius. And the Mauritian treaty brought the tax from 30 down to 0. So if you invested directly into India, you had a tax. But if you went through Mauritius, then you go to 0. And that is called treaty shopping. So when you see an intermediary, Mauritius, Switzerland, Dubai, Luxembourg, sometimes Netherlands, they often provide a very low rate. And therefore, people will go through that rather than going directly. And a lot of the rules now are saying you can't do that if one of your principal purposes of putting that intermediary company there, we're going to deny the treaty benefits and forget it. So on that note, I will close.
Thank you. Thank you so much, Professor. I mean, it's unbelievable at the time that is required to discuss and unpack these issues of tax treaties, because there's so much to learn and there's so many legal and tax norms to unpack. And, you know, you've done a fantastic job for us to start thinking about how we really interpret tax treaties. So thank you for giving us the general overview on DTAs and then touching on the specific clauses that we're supposed to pay attention to in deciding where to attribute taxation. I encourage our attendees, who are now at least 133 of them, to please ask the good professor any questions that you have through chat or by using the question and answer tab. He's here with us. And then you'll also have a chance to ask your questions directly at the end of all presentations. So now, I'd like to call upon our very own, our learned colleague, Edward Balaba, who is a tax manager at PKF Taxation Services, I think, in Kampala. And he also teaches tax law at the Law Development Center in Kampala and the East Africa School of Taxation. So Edward's presentation is going to be about East Africa Community's approach to double taxation agreements. Again, all about legal interpretation and dispute resolution. So Edward, the floor is yours. Oh, Professor, if you would stop sharing your screen,
No,
please.
that's what I'm trying to figure out how to do. My PA. My apologies. Just ignore me. We will disappear in a moment.
Thank you, Leila, and thank you, Prof, for that extensive presentation. We have had the benefit of being taken through the conceptual perspectives as far as the tax treaties are concerned. My job will be to try and give it an experiential perspective, purely from East African community. Just a second, let me just have my slide deck shared. Sorry, just a second.
Leila, you're on silent.
Sorry, I was saying, Edward, there's an echo when you speak. Maybe you could come a bit closer to the mic.
So the slide deck is visible.
Yes.
So yes, East African community, and as far as what has our journey been like, what is the network, the treaty network across East Africa? East African community. All countries in the community have double tax agreements. We have Kenya with about 15 tax treaties. Those are purely double tax agreements. We have Rwanda with about 12. We have Tanzania with about 9, and Uganda with 9 as well. Now, these are treaties that are in force. So effectively, they are actually applicable. They are available for use. But there are also treaties that have either been negotiated but are not yet in force. Usually because either the ratification process is not complete, or we don't yet have an effective date for them. So, for example, in Kenya, we have the treaty with Mauritius. That treaty at some point was declared void by the courts in 2019. But around 2020, we had the same treaty again gazetted, but it's not yet enforced. In Rwanda, you have a treaty with Barbados that was equally finalized, but the ratification process is not complete. We have had recently from press reports that Tanzania concluded a treaty with United Arab Emirates. And in the case of Uganda, there have been some treaties negotiated and completed, but still not enforced. For example, with Belgium, with China, with UAE, and of course our own East African Community Treaty, for which we don't yet have it enforced as well. So that's the landscape. That's how the treaty landscape looks like across the region. And as you can see, some countries are a lot more aggressive at it, especially Rwanda in the recent past, given its ambition as a financial investment hub, has had to conclude a lot more treaties, and many are actually being negotiated. Sorry about that. So what is it then that we have is other than the double tax agreements that I've mentioned, we also have tax treaties that are not necessarily double tax agreements. So what do I mean? It's either a multinational or rather a multilateral agreement, in which case it's not about two countries. An example of that is the East African Community Treaty. So we have a treaty that was negotiated between the East African Community countries. That treaty was approved in 2010 by the Council of Ministers, but we don't yet have it enforced, because I think it was awaiting ratification from Tanzania. And then the question there is, what ideally would happen is, now that the East African Community has grown, and we have South Sudan, we have Democratic Republic of Congo, possibly it's unlikely that we'll have it finalized in its shape. And maybe we'll have to go back to the drawing board and have a broader treaty, including those other new members. But it does exist. It's not enforced, so it means it's not being applied. The other set of treaties, again, like Prof explained, we have treaties that have a focus on administrative assistance as well as exchange of information. So inbuilt in many of the treaties across East African Community, there's an article, or there are articles that provide for assistance in collection of taxes, but also exchange of information. Now, those articles are unique in a sense that, unlike the other articles that clearly restrict the treaties to residents as persons covered, or income tax as tax covered, the articles on exchange of information and administrative assistance are much broader. They apply to the need to exchange information as far as nationals are concerned. Now, those nationals need not be residents. And then information can be exchanged even when it's not about income tax. So in a sense, within the double tax agreement, the clauses that deal with administrative assistance and exchange of information are much broader. They comprise agreements that are slightly much broader than all the other articles within the same double tax agreement. There's been another treaty, the Multilateral Convention on Mutual Administrative Assistance in Tax Matters, under the OECD, specifically the Global Forum on Transparency and Exchange of Information. So that treaty is primarily concerned with exchange of information between the parties to that treaty. And interestingly, all East African community countries are actually members to that treaty. Initially, it was restricted to OECD countries, later opened up to other members. So we have had, ever since it was opened up about, I think 2011, we have had all East African community countries join. So effectively, they are members of that as a treaty as well. And what that also means is you can safely say that they possibly now have a treaty with all those over 100 countries that are members to that multilateral convention. Because that has gone a long way in having to facilitate exchange of information across these countries. It's now much easier for East African community countries to actually access or gain or obtain information from all the other members of this convention. In Uganda specifically, one of the agreements that have been recognized as for income tax purposes is the intergovernmental agreement on the crude oil pipeline. And again, this is the pipeline that will move Uganda's oil from Uganda all the way to Tanga in Tanzania. So within that agreement are tax clauses. So what the tax laws have done in Uganda is to recognize that agreement as a tax agreement for both income tax purposes and other tax purposes. So effectively, the clauses that sit within that agreement are actually recognized and enforceable in Uganda, like the case would be for any other tax treaty or any other double tax agreement. So that's the broader scope as far as East Africa is concerned. That's the landscape of treaties across East Africa. Now, Prof has explained about the need for recognition of treaties under the municipal law. Now, treaties are part of international law, and we all know that international law ought to be ratified, domesticated for it to obtain recognition in the local countries. So this has not spared treaties. So there has been a need for these treaties to actually follow these ratification procedures. In Uganda, once the treaty has been entered, it's automatically domesticated. There is a law to the effect that every treaty shall have effect as if it's contained in our very own income tax act. Effectively, that domesticates the double tax agreement. There have been challenges across in Kenya back in 2019 when one of the treaties, that's the Mauritius-Kenya double tax agreement, actually had to be nullified by court when the Tax Justice Network Africa took a case at the court. And the issue was the legal notice that under which that treaty had been gazetted had not been presented to Parliament for approval. So the courts ruled that made the treaty void. And like I said earlier, government had to go back to the drawing board and have another treaty with Mauritius finalized and gazetted. So this is what we see in as far as recognition is concerned. So ratification processes are got to be complied with, treaties are got to be domesticated, without which then they would not have the force of law in the respective East African community countries. As far as recognition is concerned, we have also had the prevailing circumstances that there's been a bit of pressure, either because of the civil society organizations who have made a case that many of the treaties across East Africa or for the East African communities actually fall short of providing economic benefits to developing countries generally. And that was the argument even in the Tax Justice Network case in Kenya. And the courts just didn't pronounce on it, themselves on it, but it was a key argument. So what that pressure has done, together with the global trends, the base erosion, what Prof earlier discussed, multilateral instruments and all. What these have done is that they have had an effect on treaties. In Uganda, for example, there is now a cautious approach. Back in 2014, the government actually declared a temporary suspension on negotiation of treaties and embarked on having to formulate a policy on how treaties should be negotiated, which policy should be complete now. But since then, we have still not had any treaties finalized. So, I mean, into force thereafter. So there's a cautious approach in order to try and understand whether indeed the treaties in their specific form actually offer the required benefit. And then there have also been problems with consistency, whether or not all the treaties are actually tailor-made to provide, to drive the same policy that government wants to drive. It's also because of those pressures that we now have renegotiation of double tax agreements. And this has happened across the East African community countries. Kenya renegotiated its treaty with India. Tanzania renegotiated its treaty with India as well, and they now have new treaties. Tanzania largely, of the 9 treaties they have, many of their treaties are really edged, because I think 6 of the 9 are treaties from 1960 and 1970. So again, there has been a lot that has happened, and there are many treaties that are being renegotiated on that basis. But the other reason could be the pressures that are coming either from the global trends and the changes, as well as the pressure from the civil society organizations. Then, as earlier said, the Netherlands treaty with Kenya, even before it would take effect or become effective, actually had to be suspended in 2021, and efforts to have it renegotiated as well. The treaty between Mauritius and Rwanda has since been replaced by another treaty that was finalized in 2014. So renegotiation of treaties seems to become a norm across the East African community countries, and there are considerations even from other countries to have some of the treaties possibly renegotiated. Application, and so there is the issue of treaties being recognized, but even when the treaties have been recognized, in terms of their application, we see that there are limitations to their application. The countries, especially where they have not found it easier to renegotiate, have found a way around making the treaties either ineffective in a way, or have them tamed in terms of their reach and their benefits. So there have been preconditions, and these have largely been passed under domestic law. But those preconditions under the domestic laws or the municipal laws of the East African countries have actually override the treaty. So in a sense, even when, like Prof earlier indicated, treaties will largely override or prevail over the local laws, there are certain aspects where the countries, the East African countries, have insisted that the treaties will actually not override. One of those is the limitation of benefits clause. So again, unlike elsewhere where you find this limitation of benefits possible inbuilt within the treaty, what the East African countries have done is that they have placed a limit on benefits. And these benefits are usually the reduction in tax that has been offered by the treaty or a complete exemption from tax. So what the countries have done is to have an overriding limitation on benefits clause by imposing conditions. And it's only if those conditions are satisfied that you will have a resident of the other country benefit from a treaty. In Kenya and Tanzania, you have the underlying ownership condition. So that condition is the effect that if you're a resident of the other treaty country, for you to benefit from a treaty, the underlying ownership, and we are talking about an entity here, the underlying ownership of that entity must be held by residents of that country to an extent of at least 50%. The individuals, so the underlying ownership is about the ultimate individuals that are behind that entity that wants to enjoy the treaty benefits. So those tests stand, and for as long as you can't meet them, it doesn't matter that you actually incorporated in that treaty country. You will not enjoy the benefits, especially around withholding tax. If the withholding tax rate has been reduced from 15 to 10, you will not take the benefit of 10% if you don't meet that test. Uganda used to have exactly the same test for underlying ownership, which then was changed, but substantially it's more or less the same condition. Because what Uganda now has is what is called a beneficial ownership test. And by this, it's not the beneficial ownership as understood by the treaty, but the Ugandan laws have defined who a beneficial owner should actually be. So it's largely a natural person. So a natural person that has control over that company that wants to benefit from the reduced rates should be also a resident of the treaty country. So if the natural person is not, then you will not benefit from the treaty. So that test has been employed, and there are many companies that are now unable to enjoy the treaty benefits because their underlying owners are actually not residents of the other contracting state. Together with that is the economic substance test. That is the effect that you actually should have economic substance in that country. So it's not enough to be incorporated or registered in a treaty country. You must prove that you have economic substance in that test for you to enjoy the benefits of the treaty. Luckily enough, all these tests do not apply to public listed companies. The logic here is it's extremely difficult to ascertain ownership of a public listed company, given how quickly ownership changes hands, because the company is trading its stock. So the tests, both the underlying ownership test and the beneficial ownership test in Uganda would not apply to public listed companies. The rest of the other companies that are not public listed will have an obligation to confirm that they meet those tests if they are to enjoy the treaty benefits. The other limitation imposed is around a general avoidance provision that is imposed. This is imposed across, if you check Uganda's domestic laws, the Income Tax Act, the Tanzanian law as well as Kenya, there is a general avoidance provision that if it is ascertained that the transaction is one whose purpose was avoidance or reduction of tax, and the commissioner, and by that we mean the revenue administration, is empowered to either recharacterize that transaction or even disregard it. Okay? So if the form does not reflect the substance of the transaction, you will not be able to use the treaty as your shield, because again, the commissioner will have overriding powers over that treaty. And the other one is about readjusting. So again, as far as transfer pricing is concerned, the commissioner's powers to readjust prices for incomes and even deductions applies and overrides the treaties. So regardless of what the treaty provides, the general anti-tax avoidance provision will supersede the treaty in all these East African community countries. So this is the space within which treaties operate, and if you ask me, it keeps shrinking. So dispute resolution. So treaties and how then you have disputes resolved. So this is at several levels. Either most of the disputes are resolved within the revenue authority. Those that can't end up externally, they will have to have external dispute resolution mechanism. Now, talking about double tax agreements, they have a special inbuilt procedure called the mutual agreement procedure, the MAP process. The MAP process is unique to treaties, and treaties have that inbuilt procedure. So treaties are largely amenable to agreements and negotiations between the countries. So what happens is merely by mutual agreement of the mutual agreement of what we call competent authorities, the dispute will always be resolved. So is that special procedure mandatory? So case law coming from Rwanda, in the case of Lukarari Lenoa, indicated because the revenue authority, the Rwanda Revenue Authority was arguing that the case was incompetently before court because it related to, there was a treaty between Mauritius and Rwanda, and that Mauritius service provider, supplier rather, ought to have used the MAP process. So the courts in Rwanda emphasize that there is no obligation that one should use the MAP process. In fact, because the article says the person may present their case under the MAP process, it essentially means that they have an option. So they can either choose the MAP, which is the mutual agreement procedure, by engaging the competent authorities, or they can resort to local law remedies. So they can choose to go the court way, the local court way. Do treaties supersede domestic tax? Has been another argument. For example, can you disregard can you disregard the MAP process and instead of for the domestic tax resolution process? There's an interesting case from Uganda in White Sapphire where the High Court said that under the Mauritius-Uganda double tax agreement, the proper forum should actually be Article 26, which is on mutual agreement procedure. So in a sense, they actually said the plaintiff in that case ought not to have gone to court because the matter ought to have been settled by the competent authorities under the MAP process. So that in a way seems to conflict with the Rwanda experience, which is slightly different. Can one run both concurrently? Can you have MAP process, or can you actually resort to the MAP process after you have failed in the court process? Now that's debatable, but generally speaking, it's uncommon. But what we have seen again from Uganda is we have the same international BV case affecting the Netherlands. Uganda double tax agreement, where we had the Netherlands resident refer the matter to MAP or mutual agreement procedure, even after they had obtained adverse court decisions. So in effect, but again, like we said, the mutual agreement procedure is about mutual agreement by the competent authority. And that has been part of the challenge with this procedure. One, it's purely down to what the competent authorities agree. So they may even negotiate around a tax or tax laws. They don't necessarily have to fully comply with them. And then these are private cases, so you don't have the benefit of precedents coming out of them. And neither are they commonly public in the sense that you can possibly refer to them or use them for future guidance. But it's available as a process, and the treaties tend to emphasize it as the go-to dispute resolution mechanism. So talking about the competent authorities, these are the center of the MAP process, but also other processes like exchange of information. So who is a competent authority? A competent authority is usually highlighted within the double tax agreement. When you scan through the double tax agreements across East Africa, most of them either appoint the Minister of Finance or the Ministry of Finance, or in some cases, the Commissioner in charge of tax. And then they indicate for their representative. So in practice, what you see that many of the countries, the ministers will then delegate that competent authority office or role to the revenue authority to be the one to manage it. So these competent authorities are very helpful in as far as facilitating the mutual agreement where disputes have arisen. So in the White Sapphire case from Uganda, we actually, the High Court citing Article 10 of the Mauritius-Uganda DTA referred back the dispute, because that provision indicated that competent authorities will settle the limitations as far as dividends are concerned. So in the wisdom of the judge or the High Court, that meant that the matter should actually be referred back to the competent authority. Good enough, in this case, the competent authority was also a party before the court. So the respondent in the case happened to have been the competent authority under the treaty. So the case was referred back. So again, as far as the interpretation of these treaties is concerned, usually there is a reliance on the commentaries. The treaties generally follow the model tax conventions, as Prof. Ali explained. So those model tax conventions have extensive commentaries on how the treaty should be applied, complete with illustrations. So especially before the revenue authorities, you will find that that is always used as helpful guidance for the positions that they take. The case may be different for courts, because again, like you know, courts will always insist and highlight that those are only persuasive. And where the courts think otherwise, it will not matter what the commentaries state. And we'll see that in the case of Tanzania, just in my next slide. So that's important. So dispute resolution, you have reliance on commentaries. Two, you have exchange of information also forming a central part of how disputes are resolved, especially tax investigations. Tax investigations, the EAC countries are heavily using protocols like the mutual conversion, the multilateral conversion we spoke about earlier, to have those resolved by having the benefit of additional information from the other countries. So let's delve into some cases or how the courts across East Africa have dealt with treaty issues. So there has been a bit of activity around, especially from investors, and these are investors in mining, in oil and gas, and many other key industries. Now, business profits, and this is something that Prof emphasized earlier. The notion under the treaties is that business profits will be taxed in the state of residence. The exception is where those business profits are attributable to a permanent establishment. So if there is no permanent establishment, then the state of residence will actually have the taxing rights over business profits. So that has happened. In Uganda, we have had the target well control case, where Target Well UK supplied equipment to Target Well Uganda, drilling equipment. And the question was whether those lease payments for the equipment should actually be taxable in Uganda or taxable in the UK. I mean, that's to the UK entity. So the courts, the High Court in this case, emphasized that there was no evidence that the Ugandan company was actually a permanent establishment of the UK company. And therefore, in the absence of a permanent establishment, business profits can only be taxed in the country of residence. So that country of residence in this case was the UK, because that was under the United Kingdom Uganda double tax agreement. Similar issues have arisen in Rwanda under the Rwanda-Mauritius double tax agreements in a case that I earlier referred to, Dakrel Lenoa. So in that case, the Mauritius-based residents applied medical consumables and equipment to several government institutions in Rwanda. And the government institutions in Rwanda insisted on withholding tax. So when the matter came up before the courts, which is the Commercial High Court in Rwanda, the court emphasized that it was very clear that those were business profits and they can only be taxed in the state of residence, which was Mauritius. Of course, again, they had to first rule out the fact that the Mauritius company did not have a permanent establishment in Rwanda. Had it had a permanent establishment in Rwanda, then Rwanda would have had taxing rights over those payments. It's been the same thing in Kenya as well, under the Kenya-German double tax agreements in the case of Man Diesel. So again, this was a case involving an EPC contract. So you have several components of that contract. So the supply of equipment was being done by Man Diesel Germany, but the services in Kenya were being provided by Man Diesel Kenya. So the question was whether or not Kenya had taxing rights over the supply of equipment fees as well. And the courts emphasized clearly that the income from the equipment is not attributable to the Kenyan entity. And so because it wasn't, Kenya had no taxing rights. Kenya had taxing rights on the installation services, which happened in Kenya, but the goods that were supplied from offshore were actually, the income there too was only taxable in Germany. So this issue has been tested nearly across all East African community countries. What has been controversial on the other end is a scenario where the courts have attempted to make a distinction between service fees and business profits. And this has been where the countries have double tax agreements, but in those agreements, there is no specific article that deals with service fees or technical fees or professional fees. So it meant that the courts then had to establish as such service fees business profits. Was from our earlier discussions that business profits are only taxable in the state of residence, or are they actually not? So in Tanzania, the Court of Appeal in Tanzania, and these are cases that have gone through 3 stages: the Appeals Board, the Appeals Tribunal, and the Court of Appeal in Tanzania have all emphasized one thing, that service fees are not business profits. So in 3 cases, in just the last 2 years, including one a few months ago, the question has been, should you actually have service fees being considered as business profits? The answer in Tanzania has been no, they are not business profits, so they should fall under an article on other income. And interestingly, in the South Africa-Tanzania double tax agreement, other income is taxable where it arises. So it's a departure from the OECD model, tax conversion, where other income is taxed in the state of residence. So in all the cases in Tanzania, Tanzania has actually emphasized that they will have taxing rights. Now, that is irrespective of the fact that that is not what the commentary says, because the OECD commentary on their model tax conversion emphasizes, 1, that profits should be defined broadly, and then 2, business includes professional services. Those arguments have been forcibly made before the courts, and the courts insist I mean, they are only a mere guide and they are under no obligation. They're not binding. So that has been the case in Tanzania, and it's run through 4 or 5 different cases. So it's been emphasized. In Kenya, it's the totally opposite position. Remember, the treaties we are examining here are all treaties with Tanzania, with South Africa. So it's the South Africa-Tanzania double tax agreement. It is the South Africa-Kenya double tax agreement. So in the case of Magnitsky, the professional fees that were paid, the tribunal, and this is the case before the tax that was dealt with by a tax tribunal in Kenya, clearly emphasized that professional fees are actually part of profits. They should be dealt with as business profits, and therefore they should only be taxable in the state of residence. The Kenya Revenue Authority has appealed the case. We are yet to see what the courts will decide on that matter. As I conclude, we have also had interpretation of treaties across different issues, especially definitions. So in Uganda, we have had definitions in the treaties invoked. I mean, once it's determined that the treaty is applicable, then the definitions have applied. So definitions for resident, person, national, and then in cases where the treaty does not provide the definition, the treaty provides that the meaning in the local states laws will actually be taken, and that has also been emphasized. Again, in Uganda, and exactly the same treaty, Mauritius, Uganda, we had the definition of immovable property in that treaty being used to determine whether or not capital gains tax were taxable in Uganda. So here you had capital gains arising from disposal of a license, an oil and gas license in Uganda, and the question was whether or not that was those were proceeds from immovable property. Now that double tax agreement with Mauritius provides that property that is accessory to movable property is actually movable property also. So the tribunal, tax appeals tribunal, indicated that because the licenses are accessory to the immovable property, which is the oil fields and all, then that was immovable property, and therefore capital gains arising all should be taxed in Uganda. Now, as I conclude, there are many issues that have not had to be possibly explained or interpreted. Uganda had an opportunity in the White Sapphire case where pertinent questions about treaties had been raised. Unfortunately, no answers were offered because the matter was referred back to the competent authority. So in that case, if I may, and these are issues that are very important across all the East African community countries, we've since established that all countries have limitations, either underlying ownership or beneficial ownership. So that case, one of the arguments from the Revenue Authority was that White Sapphire was not entitled to a reduced rate of 10% because they did not meet the underlying ownership test. So that issue wasn't completely tested. And related to that, the question or the response from White Sapphire was that the underlying ownership test had actually come into law after the treaty had been finalized. So how would you handle a situation where you have a treaty that is prior to the law? Does the new domestic law apply retrospectively to affect the treaty? So that was another valid question that didn't come to be resolved. The other question in the same case, overriding all the others, was the fact that the Revenue Authority insisted that this was a treaty shopping scheme. Prof has explained how treaty shopping works. In this case, that company was owned by one shareholder. That 100% shareholder was actually a Kenyan national, but the company was a Mauritius resident company. So the question was whether or not that company should benefit from the treaty, especially as far as the reduced rates on dividends are concerned. So with that said, Lyra, that is a bit of what it is
Nashukuru.
that is happening across the East African community.
Thank you. Thanks, Edward. That was very, very strategic, purposeful, and spot on in terms of looking at, what are those legal clauses we need to pay attention to when it comes to resolving disputes. So I really appreciate your presentation and, keeping it to time. Please, my colleagues who are listening in, kindly ask all your questions using the Q&A tab. All presentation slides are going to be shared with you. I now call upon Dr. Martin Heersen. Martin is a friend of the East Africa region and Africa broadly. He is a research fellow at the Institute of Development Studies in the UK and the research director of the International Center for Tax and Development. Martin today is joining us to speak about his book, which he titles Imposing Standards. So here we're going to listen to Michael in addressing what are the problems with tax treaties, where is Africa positioned, and generally to get a feel of what the North-South dimensions on tax are. Martin, the floor is yours.
Thanks very much. Are you seeing my slides?
Absolutely clear.
Great. Okay, thanks very much. Thanks for the invitation. I'm going to try and keep my talk a bit shorter than otherwise to make sure that we can finish and have a bit of time for Q&A. But it's really nice to be here. It's been really interesting to listen to the other presentations. I hope that I'm going to give a slightly different perspective on tax treaties in the talk that I give now, which complements nicely what we've had from Keith and Edward. Okay, so my book and the story I want to tell you is about double taxation agreements, although I'm going to refer to them as tax treaties, because I think a lot of the time double taxation has become much less important as the reason countries choose to sign treaties, and also their main impact on countries nowadays. And it's going to focus on treaties between developed and developing countries, or lower income countries and higher income countries. I'll talk about East Africa, but also more broadly, because the field work for my dissertation is, for my book, sorry, is from Zambia, Vietnam and Cambodia. And I also have some interesting snippets from archival research I did looking at how the British Civil Service discussed tax treaty negotiations with lower income countries. So the story is about the relationship between lower and higher income countries, but it begins here in London, in my office where I was researching this book at the London School of Economics. So I sat in this office and as part of the research, I came on fieldwork in Africa, and I arranged to do that working with Tax Justice Network Africa, based in Nairobi. And they agreed to cover my costs to come and do the fieldwork, and in return, I wrote a consultancy report for them. And they sent me a contract, and the contract said, TG&A will withhold tax on the consultancy fee at the relevant rate. And originally it said 20%, which is the rate in Kenyan law. And I wrote back to them, I said, well, it's not 20% in this case because of the UK-Kenya double taxation agreement. Here you see the relevant article of the relevant paragraph of the UK-Kenya treaty, which specifies the maximum withholding tax rate on management fees, which includes consultancy fees, charged to a British person providing services in Kenya is 12.5%. So they amended the contract. And then I realized that the treaty in question had been negotiated just across the road from my office. This is a place called Somerset House. And Somerset House is quite interesting. It's now a place where you can go and watch open air films, see art exhibitions, go to a restaurant. But during the 19th and 20th centuries, it was the seat of, well, two things. Originally, it was the seat of Britain's Navy, and a lot of the expansion of the British Empire was administered through the headquarters of the Navy at Somerset House. But it was also the headquarters of the British Inland Revenue, and that continued right through to the end of the 20th century. And the argument I make in the book is that the Inland Revenue in some ways took over some of the work of running the British colony, in the sense that what the Inland Revenue was doing was negotiating a large number of double taxation agreements with countries that were former colonies and countries that had never been colonies. And the function of those treaties, from the perspective of the Inland Revenue, was to protect British businesses from taxation that the Inland Revenue considered to be unacceptable in those other countries. And so it was a different way of ensuring the same mechanism through which the colonizing state extracts capital from the states that it colonizes, this time in its neo-colonialism as opposed to true colonialism. So that's the narrative that I give in the book, and I'll hopefully unpack that a little bit for you now. Okay, so the treaty was concluded at an in 1973 at a round of negotiations in Somerset House. But from the archives, I can see that it took quite a while to conclude this treaty, and because Kenya was actually quite a tough negotiator. So the history of this is actually that a few years earlier, when the East African states became independent from the UK, their tax administration was conducted through the East African Tax Office. So it was centralized for Kenya, Uganda and Tanzania, and the treaty negotiations took place originally through that office. And then as the East African community at that time fragmented a bit, it transferred to the individual states, and they each took a different attitude. So Kenya negotiated really hard with the UK, and I'll show you about that in a second. Uganda wasn't interested and walked away, although the British tried really hard to get a legal opinion that would allow them to keep the EAC negotiated treaty, which had never been signed, to make that be treated as in force, but they didn't succeed. And the Tanzanians spent a while considering what they wanted to do, and eventually decided not to sign with the UK. This is at this time in the 1970s. So let's have a look a bit about the Kenyan negotiations. I just want to show you one bit of them, which is this memo, this telegram. So it's a telegram sent by the British negotiators from Nairobi back to Somerset House in London in 1972. And they say, talks with Kenya have broken down over the treatment of management fees and royalties. The Kenyans have pressed me to obtain confirmation from the board, that's the Inland Revenue, that the UK cannot agree to a 20% withholding tax on management fees and royalties. And eventually they get a response from Somerset House, from their bosses, to say that's correct. We can't agree to a 20% withholding tax. And that causes a stalemate in negotiations for a year, until eventually the UK actually, the UK agrees to 12.5% and Kenya comes down, and they meet in the middle. But what I like is the bit that follows. So on Sunday, we're flying to Tanzania for talks at the request of the Tanzanians. I'd be grateful if you'd get a message to my wife that I'll probably not be home until Wednesday. And what I think is interesting about this is, imagine how different this world was in the 1970s when this agreement was negotiated. That this poor man's wife had no idea when he was coming home, no way of communicating with him, would get a call from his colleague saying vaguely that he would be home probably on Wednesday. And contrast that to how things are now, where we are, I'm talking to you from the UK. Layla, I think, is also in the UK. We're broadcasting all around the world. And yet, the taxation of service provisions between the UK and Kenya is still governed by this treaty, still limited by this treaty. When I did this consultancy work, the tax that I paid in Kenya, or in the end didn't pay in Kenya, was determined by an agreement signed in an era of telegrams. And I think that's a really important part of the story, that many of the agreements that we're talking about were negotiated in a completely different set of economic and political circumstances, and yet they're still in force today. And as Keith said, it's difficult for many states politically to imagine terminating those treaties. And often if they want to renegotiate them, the other state says, no, can't renegotiate, or else wants a big price for the renegotiation. So this historical context, I think, is really important. So the aim of the talk is to explore why we have so many tax treaties signed by lower income countries, given that there is a live debate about whether or not they are beneficial. Not that there are not some benefits from them, but that the costs in terms of revenue given up may exceed the benefits in terms of potential investment promotion. And so here's a typical quote that illustrates that viewpoint. This is from somebody who negotiated for an Asian country and was a commissioner of Inland Revenue. Actually, if I had a choice, I would scrap all of the double taxation treaties, because that was really a concept put there by developed countries to help their multinational companies. So I'm not arguing that all treaties are always bad. I'm arguing that probably there are quite a few treaties in place where the costs exceed the benefits and where it would be worth evaluating them, and that this isn't perhaps surfaced as much as it should be in discussion about tax treaties. So how do we get to this point? I'm going to make 4 points to get us to the conclusion. The first point is how policymakers see this, and by policymakers I mean not people who are in the depth of the tax detail, but the political actors, the political appointees at the top of civil service. And I think a lot of the time, and also actually this also applies sometimes in business, not to the tax people inside business, but to their bosses, the generalists. And for these people, tax treaties are about investment promotion. It's simple. You sign a tax treaty, you'll get more investment. Here, for example, is a quote from the Ministry of Finance of Peru, which did a survey before they began to negotiate tax treaties. Tax treaties create a favorable environment for investment. In signing a tax treaty, a country is sending a positive signal to foreign investment and offering investors security. Now, that all sounds well and good, but if you look at the econometric evidence, we cannot say with any certainty that tax treaties lead to more investment into a country. That's not to say there aren't good reasons to sign them, but there is no evidence to support this viewpoint in a very general sense that tax treaty will always lead to more investment coming in. And indeed, an African negotiator said to me this: African countries have been brainwashed into thinking that they need treaties. I think that's probably one nuance to this story, which is which actually didn't come up so much in the previous talks as I think might be justified, which is to talk about tax sparing clauses within treaties. So if you look at the negotiations between the UK and African countries, and more broadly than African countries, in the 1970s, or say Vietnam's treaty negotiations in the early 1990s, one of the main objectives for the lower income country is a tax sparing clause. That's a clause that will say, if a business benefits from a tax incentive, a tax exemption that's listed in this clause of the treaty, then it will receive a relief for double taxation, a credit for tax paid abroad in its home country, even as if it had paid tax, even though because of the tax exemption it didn't. And the purpose of that is to ensure that the gain from the tax exemption goes to the business. It doesn't simply accrue to the home country, the multinational, which gets more tax revenue because less tax revenue was paid abroad. And when credit systems were much more common than they are now, that was a really important part of the motivation for tax treaties, not just on the part of the lower income countries that wanted their tax incentive systems to be more effective, but also on the part of the higher income countries. Because what I see very clearly in the archival documents from the UK is that the British civil servants were under a lot of pressure from businesses saying, we want a tax sparing clause so that we can benefit from the tax incentives in this country, like our competitors from other countries are benefiting. And so this was a mutually beneficial arrangement to include a tax sparing clause, although often the way it was portrayed by the UK was like something the UK was giving up, rather than in fact something the UK was under a lot of pressure to get out of a negotiation. So that may be one exception to this story. But today, a lot of those tax sparing clauses are redundant because of the way tax systems have changed. And in a lot of cases, there's also evidence now to suggest that they may also do more harm than good. There's a landmark OECD report that was 20 years or so old, which made that point. And so tax sparing clauses not nearly so seen as so important. But many of the terms of treaties that we see now, the way treaties have been negotiated that are in force now, reflect the pressure to get tax sparing clauses 40, 50 years in the past. And so the settlement that you see in the treaty now may not respect the interests, the balance of interests of countries with their present day tax systems, thinking about the way we now consider tax sparing clauses. So that's the first point, attracting investment. Now, I don't think that when I talk to people who are really deep in the technical detail of treaties, especially the negotiators themselves and the people that administer treaties, that they are under any illusions about the effect of treaties on investment. They know that there's no reason to necessarily expect that any treaty will attract investment. From them, often what I hear is something more like this. A tax treaty embodies the acceptable way to tax investment. It embodies, in fact, to be more precise, OECD tax standards, which we see embodied in tax treaties. They reflect the acceptable way to tax investment. And what you're doing when you are signing a tax treaty is you're reassuring investors they're going to be taxed in this acceptable way that conforms to international standards. The treaty will prevent, in many cases, the signatories from doing anything which deviates too much from the OECD tax standards. And a good example of that is what's happening currently with taxation of the digital economy, where you have countries such as India or and Nigeria, which are seeking to amend their approach to permanent establishment to bring digitalized presence in an economy within the tax net for corporate income tax. And they're finding that actually there's limits to what they can do because the treaties they've signed in the past prevent them from doing it, and they have to find other ways of approaching that instead. So the treaty is boxing in countries to tax approaches to taxation that reflect OECD standards, and that seemed to be a good thing because investors like it, businesses will benefit from it, but that's not the same as thinking that businesses are more likely to invest because of it. And just to illustrate this, I have a quote from an Inland Revenue document. This is from a very senior official inside the Inland Revenue in London. And he's sitting at his desk at Somerset House, and this is what he writes. Above all, what treaties do is they impose acceptable standards for taxing multinationals, for allocating profits and transfer pricing, where such standards would otherwise be absent. So from the British perspective, the reason they want a treaty with Kenya or anywhere else is to impose the OECD approach to taxing multinational companies in countries where they don't have confidence in the way the tax system is going to be developing. Okay, I've got another quote which I think we might just skip over for benefits of time. Well, here's this one from Vietnam is quite relevant. So Vietnam rushed out and negotiated loads of treaties in the 1990s. They did it because with the fall of the Soviet Union, they lost a lot of their main trading and investment partners, and they needed to invite in capital from other countries. And so this is the approach. It was urgent to open our door. We didn't have so much experience. And when the countries came to negotiate with us, they forced us to use the OECD model. I think what that actually reflects, that word forcing, is two things. Firstly, the Vietnamese were desperate for tax-sparing clauses, and so they were willing to accept a treaty on any terms, essentially, so long as it had a tax-sparing clause in it. And secondly, they didn't actually have yet the technical expertise to realize that the UN model would be a better thing for them, and that they could realistically ask for the UN model in the way they negotiated. And they learned over time and changed their approach to negotiation. But initially, and many of the treaties they initially signed are still in force, this is the way in which they approach negotiations. Okay, so we have a situation in which you have policymakers without the technical expertise who are saying, sign these treaties, they will attract investment. You have the technicians, the ones actually doing the negotiation, who are saying, the purpose of these treaties is to get our tax system looking good, and broadly speaking, that it meets international standards. Sometimes those objectives align and everything is fine. Sometimes they don't align. The choice of who to negotiate with might not be aligned. The desirable terms of the treaty may not be aligned. There might be different views about what a country's red lines should be in negotiations. So in that situation, the question is, who has a veto over treaty making? Who gets ultimately to decide what happens? And to explore this, I look at the negotiations between the UK and Brazil. Here you see actually a negotiation taking place. This is in the Brazilian newspapers, the photograph. The guy on the left is the Brazilian negotiator, and the two guys on the right are the British. And what happens in this situation is that Brazil, as you may know, Brazil has a slightly atypical approach to certain aspects of taxation, including transfer pricing. And Brazil is saying, we don't want a treaty on OECD terms. In certain respects, we want a treaty that reflects our priorities. And that means deviating from the OECD approach. And the UK's position is to say, well, I'll show you. This is an Inland Revenue quote. there's little use trying to educate developing countries about acceptable international fiscal standards if, when it comes to the crunch, we're prepared to sacrifice principle in order to secure an agreement. So the UK, for the tax officials in the Inland Revenue, want to walk away from this negotiation because they say, if we sign a treaty which reflects Brazil's preferences, which doesn't reflect the OECD approach that we spent a long time trying to set in stone, then we are undermining the whole project of creating a global tax regime based on OECD standards. What then happens is a lot of pressure from businesses is imposed on other bits of government to say we need this tax treaty because other countries have got tax treaties with Brazil, they're benefiting from tax sparing clauses, we're not getting that benefit and our businesses are losing out as a result. And so those departments write to the Inland Revenue saying, can you tell us about the progress with Brazil? We think it's important we have a treaty. And here's the reply. The Inland Revenue is not willing to even share the detail on who it's negotiating with. They say, at the present moment, especially, a high degree of confidentiality attaches to the progress of our negotiations. So they're just not going to say, even to their own colleagues in other government departments. And yet at the same time, here you see the briefing note for a meeting between the Inland Revenue and representatives of the tax profession and of businesses who are tax experts. And in these meetings, they are willing to share the detail of where they're up to in negotiations with each individual country. So for the Inland Revenue, there's a different approach to people with technical expertise who understand the project of disseminating OECD standards through this network of treaties, compared to how they approach other people, even in government, who don't have that same view of the purpose of treaties and who think it's just about getting any old treaty to attract investment. So in the UK case, the Inland Revenue has a strong control over the treaty making process and they can block the pressure, and there is no treaty with Brazil, even to this day, between the UK and Brazil. And there's lots of examples from developing countries where you can see changes in the balance of power between different bits of government and how that affects their approach to negotiation over time too. The final point is just about historical disadvantages. So in addition to what we've seen so far, as I've said, many of the treaties in force today are old, and the models on which they are based, the principles that underpin them, are even older. And Keith started off talking about the 1920s and the League of Nations, which helpfully illustrates that point really nicely. Here's a quote from the Indian government. The OECD principles have evolved from the perspective of only developed countries. This has resulted in serious curtailment of the taxing powers of the developing countries. And that dynamic was true at the League of Nations era, when developing countries were invited into the negotiations, but only once the broad terms had been agreed, only when it got to elaborating the detail. The same has been the case at the OECD in the negotiations around BEPS and the inclusive framework negotiations, the current negotiations that are going on corporate tax. Developing countries have been invited in, but they haven't been able to set the agenda. They've had to follow an agenda set by the developed countries. So just to assemble this all together, I'm going to talk briefly about Zambia. So here you see all the treaties that Zambia has signed, and they're plotted here on an axis. So across the horizontal axis, it's time, and the vertical axis is an index that reflects how much the treaties retain the source taxing rights for Zambia. So our higher dot here reflects the treaty with higher maximum withholding tax rates, with more UN type provisions and fewer OECD type provisions. And if we look at the history of Zambia's treaty negotiations, we can really nicely see these dynamics at play. So this group of treaties were signed before Zambia was independent. And with the exception of the first one, which is actually the Zambia EAC treaty, the treaties that between Zambia and more wealthy countries, you can see they're very low down. So they're very restrictive, very residence-based. They curtail Zambia's taxing rights a lot. They were imposed on Zambia by the UK as a colonizing power. But when Zambia became independent, the treaties didn't stop being in force. Zambia had to decide what to do. So here's what it did. It renegotiated some of those treaties, and then it signed some new ones as well. But what you can see is it's still not doing brilliantly. It's still actually signing treaties that are quite restrictive. That partly reflects the fact that when it goes into a new negotiation, the treaty partner is saying, oh, but you've already got this treaty in force, which has these terms. We want the same terms. I mean, it's hard for them to get much better than they've already got. But it partly also reflects a kind of a dysfunction in the policymaking situation in Zambia, which I haven't got time to go into. It's discussed in the book, the reasons why the Zambian Revenue Authority is very poor at negotiating, and they're kind of bureaucratic factors, really. But one thing I do have is this quote from somebody who was advising the Zambian government back at that time, who I interviewed in 2014. A tax treaty was seen at the time in the minds of policymakers as opening the door to the possibility of foreign investment. There wasn't a very good awareness of the revenue consequences. So that was what was driving negotiations at that point. And yet those treaties are still in force now. This era, that same guy that I spoke with, Charles Irish, he went to Zambia and advised the Zambian government on its treaty negotiations. And as a result of his involvement, Zambia started to become much more ambitious in its negotiations. So you see these treaties giving it much more taxing rights. So once they managed to understand the revenue consequences and to take that into account in their negotiations, they did much better. This era here, from 2000 to 2014, during this time, you have a revenue authority that's really keen to renegotiate the previous poor treaties and spends a lot of time doing that. But it can't get political agreement to sign and ratify those treaties. So they aren't signed and ratified. Instead, the 3 treaties that are signed are with China, Mauritius, and the Seychelles. And those are politically driven treaties, which the Revenue Authority considers to be regretful. But they can't, they're under political pressure to sign those treaties. And then in this final period, what you start to get is a more joined up approach. You have a revenue authority and a finance ministry which are on the same page, which have political support for what they're doing. You start to get renegotiations and you start to get treaties that are stronger in many respects. So all of these here are renegotiations. The problem is though, if we look at the renegotiations on that same index, when you start from a low base, you can only make a small improvement because what's in it for the treaty partner to give you more taxing rights back in a renegotiation? There's no incentive for them to do so. So although Zambia had a lot of political and technical backing for its renegotiations, it only made modest improvements because the historical precedent that had been set by the treaties concluded in the 1970s when they were negotiated without understanding the fiscal consequences, it really binds Zambia into its present day situation. And there's not much that can be done to improve it other than outright terminations, which for the reasons we've discussed may not be the desirable way to go. So how can things improve? Just quickly, 3 points. Firstly, we need homegrown critical expertise that's really driving the technical side of negotiation in lower income countries, not just within the bureaucracy, but also within academia and civil society that's really scrutinizing what governments are doing and offering insights onto it. Secondly, we need political and technical actors working better together, and not often we see this antagonism between what the politicians want and what the technicians want, and that produces dysfunctional outcomes. And thirdly, what we need is more effective democratic scrutiny when treaties are made, when treaty policies are set in the first place, and when treaties come up for ratification. I have got 3 examples. I'll just rattle them off. This is Cambodia, the General Director of Taxation in Cambodia. They spent a long time preparing for their negotiations, for their first negotiations. They didn't really want to sign treaties, but they were under such pressure because all of their neighbors were doing it. It became a big priority for the ASEAN region. And so they went into it with strong political and technical backing for really tough negotiations. And the outcomes of their negotiations are far more source-based and reflect the specific priorities that they identified much better than you see for most lower income countries. So that's a really good example of really good technical expertise working effectively. Nigeria and Kenya, 2 countries that have not supported, have not endorsed the OECD proposal on the digital economy. In fact, I could have just as easily have put the Kenya story up here because it's the same. But what I think is relevant to know is that when 140 countries were sitting in a room trying to reach a political agreement on this OECD proposal, and Nigeria and Kenya were saying we won't sign, there will have been a phone call to the finance minister with political pressure on them to come on board. So in order for the revenue authority in that negotiation and their finance ministry officials to maintain a position of saying, no, we're not going to endorse this proposal, they would have needed strong political backing. And so Nigeria and Kenya, examples of countries that have, it seems at present, managed to get that joined up thinking working better so that they can adopt a tougher stance in negotiations. And finally, we've already heard about the Kenya-Mauritius Treaty Court case, the Tax Justice Network Africa Court case. So I won't talk about what happened in that case. I'll just say that if the implication of that case is more effective parliamentary scrutiny of Kenya's tax treaties, both its approach to making treaties in the first place and then individual treaties when they're ratified, that will be a real benefit of the case and a real example, hopefully, for other countries, because it's once you have to be more accountable in public for the negotiations you've made, that gives you a stronger hand in negotiations, but it also means that you're less likely to give away things without the proper technical and political work behind them. Thank you very much. Here's a link to my book. It's free to download, open access.
Thank you so much, Martin. I think we will probably need to call you back and give you further time to be able to discuss the intricacies and nuances that you've talked about in your book. Really, really exciting presentations. Now, ladies and gentlemen, I do realize that we are 4 minutes over time, but with your indulgence and those of you who decide to stay back, we can open up the panel for about a 10 minutes question and answer session. Some of you have been asking questions directly, and I have posted the questions to the panelists on chat. We've got 3 questions for Professor Keith and Edward to answer, and we've got 2 questions for Martin. Martin, we've also had a lot of requests for your book, and I've also shared the link, so this is great. Oh, okay. So I do not know if the professor or Edward would like to start off with the first 3 questions that have been displayed on chat. Questions around what is a permanent establishment, and does it incorporate digital companies or those who trade in Africa using digital platforms? Can digital platforms be construed as permanent establishment? That's the first question. Great.
Okay. I mean, look, on the digital question, they might be viewed as I'm not know if they look, the usual battle is over VAT. So if you have a digital platform and you start interacting with the local country, typically what happens in VAT is you might have to register locally. But that's not about a platform. So usually the platforms, let's say the platform's in Gibraltar and it's gambling. That's where the platform sits. But usually they're transmitting messages to local people in Kenya or wherever, or Nigeria. So the question usually becomes is, if you're dealing with customers in the other location, do you have to register? But as a general matter, I would say in those situations, you don't have a permanent establishment. What you have is a VAT problem. But sometimes a VAT problem could start leading to an income tax problem on permanent establishment. I think the one issue that's being discussed is they're trying to make that a permanent establishment. So that's sort of it's sort of country by country, and it's an evolution at this point. But that's what the digital divide was all about. Hopefully that answers.
Thank you very much. Yes, absolutely. There is an anonymous question on the Q&A chat. It says, could we have a comment on the state of tax information exchange agreements by the East Africa Community States? Edward, I believe that question is directed to you.
Yeah.
Thank you for that question. You cannot say with certainty because it's something that the revenue authorities do in-house and are usually kept confidential and not published. But I can say with certainty that under that multilateral convention, there is a lot of exchange of information happening between the East African communities, East African community states, and the over 100 members of that convention. So it's actually happening, it's real, and it usually sits under the tax investigations docket.
Asante, thank you for that. And I'll probably ask one question before we close because of time to Martin. Martin, is a very important question, right? That they say, why is the UN model better than the OECD model?
Yeah, so I mean, it's not, I wonder if better is the right word. Keith at the start was talking about how, the OECD model generally grants the taxing right to, or grants more taxing rights to the capital exporting or the service exporting country. And the UN model generally grants more taxing rights to the capital importing or the service importing country. I think it's important to say, what's the starting point? The starting point is you have all your taxing rights intact. And when you sign a treaty, you give away taxing rights. It's not that the UN treaty grants taxing rights to developing countries. It's that when they use the UN model, they give away fewer of their taxing rights. And I think it's important to set it in that context. My own view is that often what happens is lower income countries start a negotiation with the UN model as their opening position. And the OECD countries will come to it, or whoever will come to the negotiation with the OECD model as their opening position. And you'll end up with something in the middle. But the UN model is not the ideal type treaty for a developing country. It's been brokered as a compromise on a committee that includes members from both developed and developing countries. So the UN model is a compromise already. And I think what we're missing is a powerful developing country model that is like a good starting point for negotiations. We have models from various African regional groupings, but none of them quite plays that role of being the more ambitious, more source-based model. Most of them are sort of broadly in line with the UN model. So that would be my answer. The UN isn't by any means like the ideal type outcome.
Thank you very much.
Yeah.
Thank you, gentlemen. It's been a pleasure hosting you and having you discuss this extremely important topic for the continent. I think I echo what many of our participants are saying, that these have been brilliant presentations, and thank you to all the presentations. And they say, East Africa Law Society, please bring them all back for future sessions. So this is definitely a round one. We should definitely be calling upon you for round 2 and round 3, where we continue this discussion going forward. Thank you for your time. We really appreciate it. I think we can now say goodbye, and hopefully we'll be in touch very soon again. Thank you.
Thanks.
Thanks
Thank
for
you,
having
guys.
us.
Most obliged. Thank you
Appreciate it.
so much. Thank you. Thank you, everyone, for joining us. Have a
Good
wonderful
seeing you again,
Friday.
Edward, and nice to meet you, Martin. Okay, cool. Thanks, Leila.
Thank
Bye.
you. Bye.